People are signing in numbers now, and so we're going to start this session. And very grateful indeed that so many of you have signed up and taken an interest in this session, where my colleague Peter Jorro and I, Mark Symes, are going to talk about current issues in appeals in the first tier tribunal, the first of our 3 sessions, which is very much designed to promote our new book, the second edition of Immigration Appeals and Remedies. And, this is the second edition of the book. Hopefully people may be familiar with the first edition. It's been a kind of major enterprise that sort of, impinged upon our time for a couple of months or more in the run up to Christmas and sometime this year as well. Very up to date. I was just checking that, there's almost 40 references to 2021 cases, which demonstrate its up to dateness. Also, as I noted on LinkedIn a few months ago, just in my original updating, I had to update 1,001 footnotes. So a major enterprise. Just I'm going to say something here, just a slight warning here, in that my laptop plays up from time to time. So were I to suddenly disappear, Pete will simply take over and I should appear very speedily thereafter. You can see on screen that there's a recording consent up there, which I'd ask you to bear in mind that by staying in the meeting, you're consenting to being recorded, and various other housekeeping issues are dealt with in the chat. We put everyone on mute when you log in. We'll take questions at the end of the session for 15 minutes or so. If you put a question in the chat, we will endeavour to engage with it, subject to our IT abilities. Okay, so something about, Pete and I worked together originally at the Refugee Legal Centre rather a long time ago now. And in fact, we worked together when the Universal Right of Appeal was created in the summer of 1993. And so we've kind of seen it all. And since then, the appeals thing has obviously got rather bigger. When Pete supervised me on the first case I ever did as an advocate, we were in Thanet House on the Strand. And there was only one immigration court in London, with the Upper Tribunal upstairs. It, of course, wasn't called that. And the first tier, as it was, downstairs. A tiny operation, whereas there was obviously a brief period where there were, nearly every barrister in England appeared to be doing immigration appeals, dealing with a great backlog of 100,000 cases or so. And since then, it's varied somewhat. In terms of what our book is about, we cover all aspects of appeals. As I say, today we're talking about the first tier tribunal, but what Pete will be covering. Have you lost me?
I think you've certainly frozen on screen and occasionally losing your words.
Can you hear
me? I can hear you, but only occasionally. So,
okay.
I can hear you now.
How about now?
Yes.
Am I back now?
Yes. So you're still frozen.
That must have just been one of those things. Okay, I'll log in and out. Well, I do. But if ever there was a kind of encouragement for me to stop talking to hand over to Pete, then obviously that is the encouragement, isn't it? Yeah. So on that note, I'm going to stop speaking and hand over to Pete to talk about some themes in recent.
Yes. So I'm going to now talk about the modern right of appeal. Now, this edition of the book follows our first edition, which we have here. This is the first edition, which we did back in 2014-15. And in this edition, we have a whole chapter on the history of the right of appeal, the developments from the Immigration Act 1971 appeals all the way through. And then we have a chapter 3 in the old edition, on the transitional appeals, the ones whereby people had made their appeals before the effect of the 2014 amendments had come in. So that's in the first edition. Obviously, that's still available if people want the history. With this new edition, and you can see there's a link to the Bloomsbury site for this to buy it, which is obviously what we want people to do. We hope it will be very useful. In the invites, you can go straight to that, and then the Bloomsbury site for the email there. Now, with the modern appeals, we deal with that in our chapter 2 in this book. And basically, Mark can do some sort of links to the PDF version, but we'll come to that. Otherwise, it's more just us looking at the book and talking. The right of appeal now under Section 82, which we deal with originally in Chapter 2, deals with the limited appeal rights for refusals of protection claims, refusals of human rights claims, and decisions to revoke protection status. And that's the new limit. So the first thing that then arises in respect to all of that is whether or not the Secretary of State has entertained and then refused a protection or a human rights claim. And to an extent, we deal with that in terms of the decisions in our chapter 1. Now, when Mark comes back, he'll be able to do some screenshots for the PDF of the book. But the starting point is this, is that whereas in the past, we had a system, Mark, you're back. And you can hear, Mark? You've muted yourself.
Sorry.
Yeah. So I've just been going through the fact that we did the first edition with the different the old appeal systems, but this one jumps straight into the new system because the old system is now several years old and there'll be hardly any appeals in the system from pre-2014. And if there are, it can always be referenced in the first edition. So I was making the point that Chapter 2, paragraph 2.1, that addresses the new rights of appeal. But the starting point before you get there is to decide whether or not the Home Office, the Secretary of State, has indeed refused a protection claim or has refused a human rights claim. So first of all, in our Chapter 1, we look at what constitutes a protection claim at paragraph 1.12, and that sets out immigration rules regarding whether or not a protection claim has been made. Now, of course, all of that is rather up in the air with Priti Patel's latest version of changes in the rules to try and limit that, but that's something for the future. So at the moment, we've still got the rules that address when a protection claim is made and when it is refused and the basis upon which it be refused. So that's the starting point for the right of appeal there. Reasonably straightforward, except for one thing that has been definitively decided recently in the case of Robinson in the Supreme Court, referenced in 2.3 of the book, deals with the point that the Home Office maintain their right to decide whether or not further representations, as per paragraph 353 of the rules, constitutes a protection claim that's been refused in order to bring in a right of appeal. There was a lot of toing and froing about that, but the Supreme Court's decision in Robinson definitively decides that issue. And all of the references, obviously, to case law are in the book. In fact, in the book, what we use in the notes is the neutral citation, and then the case reports are dealt with in the index. So the first issue is whether a person has been refused a protection or a human rights claim. And with respect to human rights claims, there's the added complication that the Home Office can decide whether or not an application constitutes a human rights claim. For example, in paragraph 1.14, we address the case of MY rather than my. And that makes the point that it's open to the Home Office to require a human rights claim to be made in a certain way by using a paid-for form in many cases with reference to the immigration rules. That follows on from the case of Alingambari, where the court noted whether a person who advanced a human rights claim has to sit within certain definitions. They have to have made a claim not to be removed from the UK, an assertion of facts that could constitute a right to protection under Article 8, and an assertion that it would be disproportionate to do so. But the particularly important aspect there, as set out in the case of MY, refusal of human rights claim in Pakistan, the tribunals held that the Secretary of State is entitled to adopt a position where a human rights claim has to be made in a particular way. And that's something that's quite important in terms of setting up the right of appeal at all. Now, we also address in this book, in our chapter 2, rights of appeal in the cases of European Economic Area appeals, which we're going to come to as a later section in the session, these new citizens' rights decisions, which we're going to come to, and we also address nationality decisions, and we set out what nationality decisions are appealable and what nationality decisions can only be subject to judicial review challenges. But we'll look at that another day. In terms of the grounds of appeal, that's all set out now in section 84, and we look at that at section paragraph 2.4 of the book. Now, at this stage, Mark, should we try using the link to the PDF and see if we can find 2.4? Maybe as an experiment.
Excellent, excellent. Let's have a go at that.
Yes, so there we are. We set out the permitted grounds of appeal, and it's important to note here that the same provisions apply in terms of the old case law of Ravichandran, that the issue be whether or not the decision would breach or would be unlawful. And in that sense, it enables and requires the tribunal to consider the situation at the date of the hearing, Ravichandran, And it doesn't matter whether or not a person has been granted a period of leave on a basis other than the refused claim. So a person who claims refugee status and is refused refugee status but is instead granted humanitarian protection or granted a period of discretionary leave can appeal under Section 82 on the grounds that the Secretary of State's refused the protection came based on refugee status. There's no issues about that anymore. All of that history of the old case law on that is gone. So there's no question now that an appeal can be lodged. In terms of Article 8 claims, we look at that at our section 2.6 onwards in the book, and the issues there are particularly relevant to whether or not a person has made the human rights claim in the first place, the MY stuff, and of course, in terms of the jurisdictional issues, whether or not the person meets the immigration rules. And we address issues according to whether or not the jurisdiction of the Human Rights Act applies with respect to the cases of Moon and other such matters. In the case of Mustafa, the tribunal accepted that a visitor could appeal again on Article 8 grounds against a refusal of a visit visa where it linked into a family visit. And there's an interesting issue there still. Now, one issue that's risen in recent case law terms are the two cases of Balajigari and arson, where the Court of Appeal has gone for the point whereby cases where the Home Office has decided that a person has cheated in an English language test, for example, the TOEIC lines of testing, or has used dishonesty in terms of their affairs with the Home Office and or the Inland Revenue, the HMRC, regarding their tax and points claiming, is something that can be set up for a human rights appeal. And those are important points regarding whether or not the Home Office accept that a human rights claim has been made. Because of concessions made in those cases, it's more difficult for the Home Office to insist in all such cases on the paid for form. But we'll look at that a little bit more when we look at new matters and so forth. So we address all of that there. We also look at revocation of refugee status and the rights of appeal in that regard, 2.7 in the book, and the point made by the case of MA Somalia regarding a cessation decision being a mirror image of a determination decision. And we also consider complications that then arise in repeals under Section 84.3 against the decision to revoke refugee status, where it's to do with Article 33.2 criminality. And the rather complicated area dealt with in the case of Dang, where the tribunal held that it's only refugee status under the old qualification directive that can be revoked on that basis, not under the Refugee Convention itself. So we address all of that in there, in that paragraph. Now, we also look at the question under the new system of when an appeal is suspensive and when not, at paragraph 2.13. And again, at any stage, Mark, you're welcome to chuck up a picture of the book. So let's have a quick look at 2.13. So Section 92 addresses the issue of when an appeal it can be brought from in country and when it can only be brought from out of country. And interestingly, in the case of Chowdhury, the High Court upheld the first tier tribunal's conclusion that it had no jurisdiction to consider an appeal brought under Section 82(1)(b) against a refusal of human rights claim made by a person in the UK, but brought by the person from abroad on the basis that the legal representatives were in the UK. The words must be brought from the UK required the physical presence of an appellant in the UK, irrespective of the location of their legal representative. So that sets it out very clearly in terms of where the appeal can be brought. The new system, 2.14, allows for the Secretary of State to block a suspensive right of appeal by issuing, after the appeal has been lodged, a Section 94 or 94B certificate relating to clearly unfounded and the human rights form clearly unfounded. And that reversed the old effect of the case of AM Somalia, in which the Court of Appeal had held that bringing an appeal is a single event. So the Secretary of State can now undoubtedly prevent a suspensive appeal continuing suspensively by issuing the clearly unfounded certificate. We also look at the limitations, the current day limitations on the rights of appeal, with the Section 94 certificates for clearly unfounded cases, and we look at the practical application of those. And we consider the new Section 94B certificates and the issue there that now applies to all human rights claims, and the fact that people can then lodge their appeals only from abroad, subject to the provisions set out in Chiari and Bindloss, where the Home Office lost those arguments then. And indeed, there's an interesting side issue on that, which is that all these appeals from abroad, in terms of being done now under the new remote hearings, and we're going to be looking at remote hearings at a future session, you have on the one hand a tendency to say that you can bring an appeal perfectly easily from abroad using remote technology, and on the other hand, the case of Nare, that says that in order to do so, you need to have the permission of the authorities of the country, or at least show that they don't object to someone giving evidence in an appeal in the UK from their territory. My understanding of that's going to be reviewed by the Upper Tribunal, because in a sense it does make a slight mockery of the new age of remote hearings. So we'll look at that. We also address the practical applications of Section 94B certification. And then we move on to look at the Section 96 certification, which addresses no right of appeal at all, where there's been an earlier right of appeal, and we consider the Home Office guidance regarding that. We then move on at 234 to deal with issues regarding when an appeal is pending. Now that's reasonably straightforward up to a point, and it still provides for people, for example, the issue of where somebody has been left the UK. So if someone leaves the UK, the basic provision is that the appeal is no longer pending. However, in the case of SB or SR Algeria, the Court of Appeal said that didn't apply where it was the Home Office having removed the person. So where the Home Office had wrongly, in contradiction of Section 878 of the 2002 Act, removed someone from the UK, the Home Office couldn't then benefit by saying, and what's more, SR Algeria, the Court of Appeal held that such departure must be voluntary, and appeal is not to be treated as abandoned on provision where independence is removed against their will. So that's the Court of Appeal sort of stomping on a Home Office attempt to say, well, we've done something wrong by removing you illegally, but now we're going to take the benefit of that by you not being able to appeal. So that's a development in the case law. Now, in terms of the appeal pending and not pending, we have quite interesting issues arise in respect to CART JRs and a series of cases regarding that, which we set out at our paragraph 2.37, cases of Samon, Niaz, and Aziz. Now, in those cases, the first one in Samon, the tribunal held that an appeal in respect to which a CART JR has quashed a refusal of permission to appeal is again pending within the meaning of the 2002 Act. In itself uncontroversial, that, because it's been brought back. In doing so, the tribunal declined to decide whether the appeal was pending after the decision of the UT refusing permission to have been given, but before it has been quashed. However, in the case of Niaz, the tribunal held that whereas Section 1042 contains the exhaustive list of situations which an appeal is pending, the corollary is that where none of those situations apply, the appeal then must have been finally determined, and that accordingly, when the UT refuses permission to appeal, then the appeal is not pending. If a CART JR is successful and the refusal decision is quashed, then the appeal starts pending again. And that's the only way the tribunal considered they could look at it. And if that meant that it was unhappy because in the intervening period, the Secretary of State removed the person from the UK, well, so be it, according to the tribunal in Niaz. On the other hand, in the case of Aziz, the tribunal held that where a person was granted leave to remain in the UK, their human rights appeal failed to be treated as abandoned under the provisions in Section 104 that provide that where a person has an outstanding appeal and they're then granted leave to remain, so this is not where the appeal is lodged, the appeal is abandoned, other than in certain cases regarding refugee humanitarian protection. They make an actual application to the Home Office and the court to maintain the appeal. So whether a person without that right is granted his leave to remain and a CART JR is awaiting decision, the tribunal's point was the fact that the appellant's appeal has ceased to be pending at the point when leave was granted does not mean that at the moment when the appeal failed to be treated as pending following a High Court squashing decision, Section 1044A had to be discarded. On the contrary, at that moment when the appeal became pending, it failed to be treated as abandoned. There's a whole series of cases there, which are quite interesting to look at vis-a-vis the effects of CART JRs on pending appeals. We then address the statutory duties of the FTT on appeals under Section 82(1), and obviously the Section 85 requires the tribunal to consider all the facts for itself, and dismissal or allow the appeal. The tribunal acts independently and is not bound by decisions, for example, of the national referral mechanism as to whether a victim of trafficking. That was definitively decided in the case of MS Pakistan in the Supreme Court. So this is paragraph 2.38. So the statutory duties of the tribunal, they have to make necessary findings of fact, which including in an arson or Balagajari type case, would include whether or not the person had cheated in the English language test, or whether or not they had cheated in terms of their tax and or lied to the Home Office about their income for points, because those are obviously facts that are then relevant to whether or not a removal is proportionate. There are specific provisions where the Secretary of State's issued certificates for serious criminals, Section 72 of the O2 Act, or 1F applications in Section 55 of the 2006 Act. All of the acts obviously are set out clearly in the beginning of the book in terms of the referencing. All of that's set out there, and they are the tribunal's duties in terms of requiring what it must do, including in Article 8 cases, the statutory obligations to consider proportionality along with Section 117A and 117B. The book then goes on in Second Part Chapter 2 to address rights of appeal in the EEA and citizens' rights and nationality appeals. Very briefly on nationality appeals, we have the important cases 2.90 of KV Sri Lanka and Begum. And the KV Sri Lanka, which has not been overruled by Begum specifically, steals quite nicely, steps out there, which we set out at paragraph 2.92, the matters for the FTT to deal with on an appeal, particularly where it's the FTT and it's dealing with precedent fact cases under Section 42. So I'm going to stop there for a bit, and we'll now move on to another topic, which Mark, you'll deal with another topic, and then I'll go back onto consent and new matters.
That's precisely right. Okay, excellent. Yeah. Well, this is an experiment with us in terms of the whole screen sharing thing, because obviously we just to say our strategy on this is obviously that Pete and I have written a book, which is kind of our contribution to the sector, and we're doing these three sessions for you. So we're not in a position really realistically to do notes as well. So none of you must put in the chat, where can I get the notes? Because of course the notes are available in our book in all good bookshops, if there's any bookshops left, and it's even available purchasable on Kindle. So there was some fairly desperate kind of screenshot jockeying around there by me, and it worked pretty well, actually. I think you could see how up-to-date the book was. You saw quite a few of our references. First of my topics I'm going to talk about is the inquisitorial process in the tribunal. And this is something which, as to which the tribunal has varied its views a little bit over time. And it's interesting in one respect that actually the first tier tribunal is much more avowedly adversarial in terms of how it talks these days, or how the upper tribunal tends to speak of how it should conduct itself, than perhaps it was before it was the first tier tribunal, even though the first tier tribunal was created as part of the great post-war legislative effort to produce a comprehensive system of UK remedies where the courts did generic major points of law and the tribunals were intended to promote access to justice to the greatest possible degree at a more basic level. Of course, immigration is perhaps one of the more adversarial theatres of English law, and it's unsurprising that the courts of the tribunal has found itself pushed very much into an adversarial process. But over time, the tribunal has kind of said different things about inquisitorial process, and I'm just going to show you one or two of the things it has said. Okay, here we get a UC, and hopefully this shows you how this shows that the book is quite comprehensive in terms of looking backwards as well as forwards. Constitutional Reform Act tells us that fairness is at the core of what the first tier tribunal and upper tribunal no doubt actually does. Much earlier, right back in the days of Geoffrey Kerr being a vice president, we see that his view was that adjudicators, as they were in those days, should take up a more intrusive role, depending on precisely how effective the representation that a person enjoyed actually was. However, how far does that go? And you see a series of cases. Where are they? Oh yes, here they are. Where the Upper Tribunal has varied in its enthusiasm for the task. It's come most live in the children's cases, where the Section 55 duty, which of course, strictly speaking, I suppose adheres more to the Home Office than to the tribunals, but which the tribunals nevertheless have to police. And of course, under the Human Rights Act, the tribunals have to police Article 8 ECHR, which includes a procedural requirement to look after the best interests of the child. Nevertheless, there were limitations on how far the tribunal might actually go. And so you see, a moment ago, we saw Remedies from the old days, but then on the other hand, on screen now at paragraph 3.5, you see the current president, President Lane, saying that actually modern proceedings bear the unmistakable characteristics of adversarial litigation, two parties opposing views, pleadings, and a clear dispute between the parties. Nevertheless, there's been another debate, little contest between the Court of Appeal and certainly Judge McCloskey, when he was president of the Upper Tribunal, about how often it would be that the Upper Tribunal or the first tier tribunal should call for extra evidence. And the Court of Appeal, in the personage of Sir John Laws, I think, suggested that Mr. Justice McCloskey had gone too far in suggesting that the tribunal should be proactive. Subsequently, the Upper Tribunal stated itself to be unrepentant as the inquisitorial role in children's cases, and then the Court of Appeal backed off, as I recall, with the next Court of Appeal judge who looked at it, saying, well, they rather hoped it would be rare, but perhaps it would be wrong to say it would be very rare. And I think Mr. Justice McCloskey, who's now immersed in the Court of Appeal in Northern Ireland, is actually continuing to issue judgment at Court of Appeal level in Northern Ireland, pushing the margin of Article 8 and the investigation of children. Okay, that's inquisitorial duty. I think the next topic I'll look at is disclosure. Yeah, so disclosure is a subject of perennial interest. And here we are. First thing to say about it is the first tier tribunal, of course, has powers in the procedure rules. Sometimes one sits in the first tier tribunal, you might think there weren't any procedure rules. They are so often referred to, but of course they are there. And although we're used to them, nevertheless, they are there as a resource. And as you can see here, the first tier tribunal has powers to permit or require persons and parties to provide documents and information relating to any of the issues with which it's charged. Also, as this paragraph reminds us, the Home Office is under an obligation to provide certain documents within 28 days, including any other unpublished document referred to in the notice of decision. And that rule, I think it's Rule 23 and Rule 24 of the FTT rules 2014, is kind of no one ever refers to it. Appellants, advocates seldom refer to it, and the Home Office operate, somewhat oblivious to it, it would seem. But there is some basis based on that rule for saying that if material referred to in a refusal letter isn't provided in the respondent's bundle, or at least shortly before the hearing, it can't be relied on. So quite an important power there. Those provisions are the subject of a consultation at the moment. In that the Ministry of Justice is thinking about amending the procedure rules in order to catch up with the modern directions for remote hearings, etc., and CVP hearings and all the rest of it, whereby there's much more case management. But all the same, that's of some interest. Disclosure of interview records, that's something we've seen, isn't it now? And surely interview records have to be disclosed. But what about comments made by interviewing officers? And there's been a bit of up and down on that. I think Mr. Justice McCloskey felt they should be disclosed if on file as an interesting contemporaneous note on the thinking of someone who saw the interviewee in front of them. This was very much in the context, I should say, of EU sham marriage cases rather than asylum cases. Asylum interviews, because of the EU law requirements, the full interview record has to be disclosed, I suppose. Whereas in EU sham marriage cases, that's simply an issue of common law fairness, or perhaps EU law driven fairness. So yeah, interesting points there. But more recently, Mr. Justice Lane tells us that actually there's no requirement to introduce into proceedings comments as opposed to records of interview, as comments are simply part of the interim decision-making process, and it's only the final view that actually matters. Redaction. So redaction, you can see there on screen in the case of A, B, C, and D, I think it was. The tribunal found many years ago that over-redaction by the Secretary of State was something that the Upper Tribunal and its then ancestors ought to police quite carefully, and they should call for unredacted or minimally redactive sources where that was necessary. And overall, as you can see there, the overriding test is whether the disclosure is necessary for the just and effective disposal of the appeal, bearing in mind the probability of evidential materiality to the requesting party's case, having regard to the principle of proportionality. And then something else which could be important in cases that might be being set up for country guidance or whatever, I suppose. The doctrines of litigation privilege and legal advice privilege, I barely knew there were two different privileges, but there are apparently, both operate. So legal advice privilege is like pre-litigation. Litigation privilege is obviously during litigation, and the Home Office is entitled to hold back correspondence between itself and its lawyers, but perhaps not entitled to hold back correspondence between it and its expert witnesses. For example, perhaps the tribunal would be entitled to call for that kind of material. Okay.
Okay, should I talk a little bit about consent and new matters?
Yeah, do.
So, as has always been the case, the correlation between section 85 and section 120, so this is paragraphs 2.8 onwards in the book, but I'll keep that for now. There's business whereby the idea of the first tier tribunal is that it should be able to deal with all matters relevant to its jurisdiction in one go. Because after all, one of the great grumbles that the Home Office have as part of the whole politics of immigration and asylum is this business whereby they say people constantly make applications in order to avoid being removed from the UK and then make another one and make another one. And so the starting point is section 85 provides that the tribunal has the jurisdiction to deal with all issues in one go on an appeal relevant to its jurisdiction, now subject to section 82, asylum, protection, human rights grounds. So you then have the section 120 business of the Home Office make a decision refusing your claim, and they can, but they don't have to, serve a section 120 notice requiring you, the applicant, to raise any other grounds on which you want to be able to remain in the UK or not be removed. Now, one of the important points about grounds is that the grounds mean the grounds now available for appeals under section 82, section 84 grounds. So in other words, the only grounds that you can now say you should be allowed to remain are that you're effectively someone needing protection or you have a human rights claim. And in response to such a notice, a person can state their additional grounds. Interestingly, it has to be done in writing. The case law makes it very clear in the case of OA Nigeria, which we set out in 2.9, that it can't be done orally at a hearing. So this is 2.8, 2.9 of the book. So the grounds have to set out a certain minimal particularity of what it is that the person says means they can't be removed. Now, obviously, if it's a refugee or humanitarian protection claim, that's relatively straightforward. Where it's human rights, all the issues regarding Alec and Jabari arise again. It's important here, though, that the Court of Appeal has made it quite clear in the case of Shrestha, S-H-R-E-S-T-H-A, that this is not necessarily a route to a cheap human rights claim. Because one of the problems we always have with this is that applications made to the Home Office usually these days cost an awful lot of money if you want to raise a human rights claim via the rules. And so you can't do that, as it were, on the cheap by being refused in a case which doesn't have a human rights element. Then a section 120 notice comes along and then you raise a human rights claim. The case of Shrestha makes it clear that the Home Office is still entitled to require you to make a paid for application rather than neatly just raise it on the human rights claim. The two potential exceptions to that, based on Home Office discretion, again relate to the cases of arson and Balajagari, where a refusal of a person on general grounds relating, for examples, to the TOEIC testing cheating system, or inconsistent declarations of money to the Home Office and to the HMRC, can be an issue on which you can raise a human rights claim vis-a-vis a Section 120 notice, because it is part of fundamental to the judgments in those two cases, a desire to get those issues in front of FTT on merits appeals rather than being dealt with on judicial review in the Upper Tribunal. So in those particular cases, the Home Office will usually accept a human rights claim being made in the Section 120 notice, but certainly not in all other cases. So that then leads on to the business of the Section 85(4) and what the tribunal consider in terms of other matters raised. Now, the previous wording before the 2014 amendments was that the FTT may consider evidence about any matter which it thinks relevant to the substance of the decision, including evidence which concerns a matter arising after the date of decision. The new wording is that the FTT may consider any matter which it thinks relevant to the substance of the decision, including a matter arising after the decision, but then immediately goes on to state that the tribunal must not consider a new matter unless the Secretary of State has given the tribunal consent to do so. And a new matter is defined as matter that constitutes a ground of appeal, because again, putting aside EEA cases and citizens' rights cases and nationality cases, you're limited to basically the protection and human rights grounds. And the Secretary of State has not previously considered the matter in the context of the decision mentioned or a statement made by the appellant under Section 120. Now, the purpose behind these was pretty clear. It was to preserve the Home Office's right to be the initial decision maker in human rights and in particular protection cases. And so it sort of deals with the problem that was caused in the issue, for example, in the old case of Chichvarkin, where the Home Office, there was an appeal pending, and then they tried to raise asylum grounds before the first tier tribunal or the AIT at first instance, with the result that the Home Office ended up having to withdraw the decision in order for there to be no right of appeal at all. And then it went to the court whether they were entitled to do that. And the Court of Appeal said they were. So now this is brought in order to deal with that. And so the clear and immediate purpose of this was to stop people particularly being able to raise asylum protection issues on a human rights appeal. There's a logic to that in my view. So initial decision maker, the Home Office. The trouble is that the tribunal seizing the issue and running with it, particularly in the case of Mahmood, decides that a new matter is anything that relating to a factual matrix that's not been previously considered. And they start getting into these kind of issues whereby if the argument is that someone's got a family life relationship with a British citizen through living together, for example, the fact that they then get married while the appeal is pending is not a new matter. So the tribunal can then carry on with the appeal without it being a new matter. If, on the other hand, while their appeal is pending, a baby's born, the tribunal says that is a new matter. And the point the tribunal are trying to make is that under the immigration rules, having a child, particularly if the child, of course, is a British citizen by birth, is a massive change in terms of how it is that the proportionality exercise would be made. So the tribunal says, oh, well, a baby being born, that would be a new matter. And of course, the problem with this is that it sort of pushes people into a situation where they have to make a new expensive human rights application, immigration rules, but basically human rights application to the Home Office, which is why it's somewhat objectionable. There's one side provision to this, which is quite interesting, as pointed out in the case of Birch, which is in the Upper Tribunal, is that the Section 85 new matter and everything else only applies in the first tier tribunal. So if on an appeal that is pending, the first tier tribunal has made its decision and it's been appealed to the Upper Tribunal, the Upper Tribunal has decided that there was a material error of law and decides to then hear the substantive appeal itself. None of this new matter provision applies. The Upper Tribunal's jurisdiction is not limited by it. It can go on to consider whether or not, as per the current situation, removal would breach the statutory wording, the person's human rights. In the Mahmood case, the tribunal held that the issue as to whether something, in practice a submission raised by the appellant, is or is not a new matter goes to the jurisdiction of the first tier tribunal and therefore has to be determined by the tribunal as to whether it is a new matter. And only if it is a new matter does it then go to the question of whether or not the Secretary of State consents to allowing it to go forward. As for that, the Home Office have guidance, which we reference. It's all obviously the guidance is referenced in the book, but it's obviously on the Home Office website. And the guidance on new matters is quite positive in the sense that the Home Office say it's always best for everything to be dealt with in one go. But where there's an issue that may be complicated, the way forward is to seek an adjournment of the hearing before the tribunal. And in the case of Quaido, Quaidoo, the tribunal agreed that that was the proper way of going forward. Normally it'd be appropriate to adjourn for the Home Office to decide whether to give consent to it being a new matter being considered or not, rather than either just knocking it out there and then, or on the other hand, accepting it as a new matter of first initial jurisdiction. And the remedy for a decision which is considered wrong on whether a matter is a new matter and or the Home Office not giving consent is judicial review. So that deals with, and it's obviously much more thoroughly dealt with in the book, the business of consent in new matters. Now, Mark, do you want to deal with another issue, or shall I talk about burdens of proof?
Just to keep the swapping thing going, yeah. Let me do an issue, yeah, and then we'll go back to burden of proof, which is a interesting and volatile topic. Yeah, okay. What I have, I'm just going to say a few words about sanctions, and sanctions are something which have entered our parlance in immigration much more in recent years. Though perhaps we don't talk about them, we don't use the language as often as perhaps the Upper Tribunal suggests we should. So let me see if I can find something in the book about this. So of course, I think sanctions cropped up in our area of law because of a crossover from other areas, and of course the cases of Mitchell and Denton were the famous decisions on this. But just to put it in context, oh, here we are. Yeah. Okay. So to put it in context, so imagine, imagine one does something out of time, and so this starts in the first tier tribunal. Imagine you lodge your appeal out of time, for example, and the classic way of dealing with that, obviously, is to apologise to the first tier tribunal and beg forgiveness and hope time is extended. And the first tier tribunal, being quite a mellow creature, will probably not criticise you for taking an informal approach. But nevertheless, as the Upper Tribunal have tried to drum into us with limited success, firstly, it's not just a bare discretion involved in these cases. The discretion is driven by the overriding objective in the procedure rules, which includes fairness. Well, probably we'd all work that out. However, because the immigration is part of public law and civil law, the relief from sanctions doctrine applies to it, and therefore a staged approach should be taken. So the first question is to evaluate what is the seriousness or significance of the failure to comply with the rules first. Secondly, is there a good reason for the failure? Bearing in mind, though, that even a serious and significant breach can be condoned because it's simply thought disproportionate to knock out a whole appeal or defence of an appeal because of even a serious breach. And finally, all the circumstances of the case. And there you can see it, footnotes 11 and 12, you see Mitchell and Denton, the two cases where, which have kind of struck a chord across the whole of English civil and public law proceedings for those propositions. Before I stop here, I have one more thing to say on disclosure, but I managed to lose my notes on it earlier, and now I've found them again. Interesting issue on disclosure is the extent to which the Secretary of State is under a duty to disclose issues of policy. And I think we probably find it around here. Yeah. So because of the decision of UB Sri Lanka in the Court of Appeal a few years ago, it's generally, for a while, the tribunals were taking the view that the Home Office had a pretty strong duty to disclose policy material, including country evidence. And UB Sri Lanka was an unusual case. I mean, lots of decisions over time, for example, Mandalia in the Supreme Court have told us, of course, that the Home Office has to disclose relevant policy, including policy that is relevant on the appellant's best case and not on the Home Office preferred analysis of the facts. However, what about the situation where there's country evidence in a Home Office policy? And that's what seems to have happened in UB Sri Lanka, where basically, I suppose it was an OGN or a CPN or whatever, was published online, and it talked about things in Sri Lanka, a particular facet of documenting asylum seekers or returns or whatever. And the Home Office guidance document quoted correspondence between the Foreign Office and someone else, maybe the Sri Lankan authorities, I forget now. Anyway, so basically what the Court of Appeal said was that that material was something that had to be drawn to the first tier tribunal's attention by the presenting officer, even though it was, you might say, slightly obscure passage in what was only one out of several long country of evidence documents that the Home Office produce. There was still that duty. And then for a while, appellant advocates made hay with that. I may even have done it to myself, to suggest that anything that was in Home Office operational guidance or country reports, whether or not it was in the bundle before the first tier tribunal, was basically fair game and should have been something that was alerted, to which the FTT was alerted. But the case of BH Iraq, which is essentially what we're looking at on screen now, kind of knocks that back and says that that duty is limited. It's only limited to where basically there's a particular kind of source which only the Home Office has access to, and which they've chosen to put into a policy. Only then is there a clear duty. I doubt we've heard the last of that topic, because, for example, at the moment we now have a situation where it would seem that the Home Office is under a lighter duty of disclosure in appeals process than it is in JR proceedings. Now, that's an interesting conclusion, and the judge, President Lane has written a very erudite judgment in BH Iraq, making the point that JR and appeals are different spheres of law. But I noticed that, for example, Chamberlain J, quite recently writing in the admin court just a few weeks ago, suddenly made a passing comment saying that immigration appeals are a species of public law, something which other judges have noted over time. And so we have a tension riding out at the moment in the case law about actually, if immigration appeals are a species of public law, which is, of course, a little bit what Begum says in the UK Supreme Court regarding nationality deprivation cases, then why is the disclosure duty different in one sphere than another? Watch this space. Okay, I'll hand over to Pete to tell us about...
Yes, we're just going to talk briefly. And by the way, questions are coming in, and we're aware of those. But what we're going to do is we're going to do our little pieces as per the advertised material, and then we'll look at the question and go through them together. Mark, yeah?
We will, yes.
Yeah. So we are going to do that. We're not ignoring the questions, but rather than just type them up while we're also trying to talk, we'll look at those after we finish these bits. So I just want to talk briefly now about the burden of proof. Now, the burden of proof in some ways is normally reasonably straightforward. The person making the assertion that they're a refugee or that their human rights would be breached by removal has to prove it according to the various standards: refugee lower, other issues, balance of probabilities. But there are certain interesting areas that arrive on this, and the first one relates to statelessness in nationality appeals. And in paragraph 293, we look briefly at that, because very, very briefly on this, the Home Office, under section 40 of the British Nationality Act, can make decisions to deprive a person of their British nationality, broadly speaking, either on the grounds that it's conducive to the public good to do so, or on the grounds that the nationality was obtained by some form of fraudulent behaviour. We're all familiar with the issues. Now, in the case of where someone's, so 2.93, in the case where a person is having their nationality removed for conducive grounds, section 40, subsection 4 of section 40 requires the Secretary of State to identify whether or not you ought to make the person concerned stateless. Now, as a result of that, in the case of Jeddah in the Supreme Court, and then followed on by G3 in the SIAC, and by the way, we have a whole chapter on the SIAC, but we're not going to talk about that today in this book, procedure in the SIAC. They make the point that since it's the Secretary of State that's seeking to deprive the person of British citizenship, the burden lies on the Secretary of State to show, on the balance of probabilities, that on the particular facts of the case, the person will not be stateless if deprived of British citizenship. So that's the case of conducive to good. However, conversely, KV Sri Lanka makes the point that there's no similar requirement to establish that the person concerned will not be made stateless before depriving under section 43 on the grounds that naturalization is performed by fraud and so forth, and therefore the reasoning in G3 doesn't apply. Rather, in terms of the proportionality exercise, which is inherent in these nationality deprivation cases, whether or not Article 8 is involved or not, if the person is saying that they shouldn't have their nationality deprived because it will make them stateless, then the burden is on them to prove that deprivation would make them stateless. So an interesting little swapping burdens there based on the statutory provision. More usually, we have the issues relating to, and this is now in the book at paragraph 3168, the swapping burdens of proof. Now, we set out here in 3168 on procedures before the tribunal a whole series of issues on the burden and standard of proof. So we make the point that the burden usually applies to those who are making the assertion. And in immigration non-asylum cases, it's always the balance of probabilities. Any attempt to have some sort of raised standard was dismissed in the case of our Ray B children case, but it applies across the board. Where it gets really interesting is when the Home Office are relying on general grounds for refusal. And then you have this weird business with the case of Muhandiragne of the pendulum swinging in terms of the burden of proof. So the tribunal says that the Secretary of State has the burden of evidentially establishing that there has been dishonesty, there was cheating, or whatever it is that the Secretary of State has decided the person's done wrong in order to warrant refusal under the general grounds. And we'll all know that the new general grounds provisions and the rules have all been changed as part of the great period during the pandemic when all the immigration rules have changed. Numerous new statutory instruments came in, and the writing of any book during that period became a major difficulty. But so general grounds, burden on the Home Office to establish. Now, if the Home Office then produce something, and in practice, of course, with these cheating toilet cases, all they produce is the ETS document saying the result's been invalidated. Then it said that the burden switches to the appellant to evidentially raise an innocent explanation, which takes account of the relevant matters and with a minimum level of plausibility, whereupon the burden goes back to the Secretary of State to establish on the balance of probabilities that the prima facie innocent explanation is to be rejected. There is still notion that the more serious the allegation, the greater must be the strength of the quality of the evidence. So this doesn't affect the fact that it still has to be probable. English law has this notion where the balance of probability applies, it's a binary system. Either 1 is being proved or 0, it hasn't been proved. But the strength of the evidence is relevant there. There are issues regarding burden of proof swapping around in cases where rights of interference in marriages and so forth, and where a general suspicion has been raised. So, for example, an appellant must prove that a proxy marriage was valid under the law of the country where it took place. But reliability in marriage certificates and is a matter for the appellant to prove. But the Secretary of State bears the burden of establishing the validity of an assertion based on something which is solely within the Secretary of State's knowledge is proof. So, for example, the cases of Basnet, and then following on from Basnet, Ahmed, making the point that where the Secretary of State is the only one who can know whether or not a payment was taken from an account, then it's for the Secretary of State to prove that it was, and failure to do so would knock out a reason for invalidating an application with all the consequences that can have. Against that, in the case of Mitchell, it was said that was not the case where a form hadn't been sufficiently completed. So where on the face of the form itself, the payment section hasn't been properly completed, then the Home Office win on that one. Where it has, but the Home Office say the money hasn't been taken, then they have to prove it. In asylum cases, the burden is on the appellant to show that there's a real risk of persecution. But if the Home Office are raising exclusion issues, then the burden lies on the Home Office to prove that the exclusion or the cessation clause applies. Though where the person says that the exclusion clause would apply except that they have the defence of duress, for example, under international law, then the burden shifts back to the appellant to produce evidence to show that the case of the defence of duress can be made out. And then finally on this issue, where there's a prima facie case on the evidence that an Article 3 breach will take place on removal, then the Home Office had to provide evidence to establish that there's protection or it's requisite treatment available to prevent that Article 3 infringement happening. So, as I say, you have quite interesting issues there of swapping variant burdens of proof and statelessness, the pendulum swinging in the general grounds for refusal cases, and a swapping round in refugee cases. So, Mark, now before we get to questions, we've still got a bit of time. We're going to talk about the EEA appeals and the new citizens' rights appeals. So these are dealt with in terms of the statutory provisions in chapter 2 of the book. Now, if I could just turn to, and this all gets quite complicated because of this Brexit business. So, paragraph 2.54 deals with the EEA regs of 2016. Now, the first point to make is that the EEA regs 2016 were revoked, completely revoked on Brexit completion day, the 31st of December 2020. That's when Brexit happened at 11 p.m. British Greenwich Mean Time. So they're gone. The regs no longer exist. If you try and look them up on the sites, they're not there. However, there are complications because firstly, provision is made in one of these multiple forms of statutory instruments. So this particular one is the Immigration and Social Security Coordination (brackets EU Withdrawal close brackets) Act 2020, with the Immigration and Social Consequential Saving Transitional Provisions EU Exit Regulations. That's the name of the regulations. Now, broadly speaking, they provide that where appeal was pending before the tribunals under the EA regs on IP completion date, and where an application had been made to the Home Office for a residence card, family permit, etc., before IP completion date, then despite their revocation, the EEA regs and the rights of appeal under them carry on in force. So not just where there's a pending appeal, but if an application is made before the 31st of December, there's still a right of appeal under the EEA regs. That's the first thing. But secondly, there's this business of the grace period extending 6 months, which we're still in, as it goes on until the 30th of June, in which applications can be made for settled status and other statuses. So this is the Citizens' Rights Application Deadline and Temporary Protection EU Exit Regulations 2020, with lots of brackets in there. They provide for the deadline for submission of applications for resident status to go on to the 30th of June. And they all link into provisions in the withdrawal agreement, the EEA-EFTA separation agreement, and the Swiss Citizens' Rights Agreement. And basically they provide for specified regs of the EEA regs to continue to have effect with modifications for applications made during that grace period, and obviously to carry on the pending appeals after it. So a lot of the provisions relating to the 2016 regs carry on in force for a long time to come, dealing with those two sides of provisions. So what we do in the book, we set out the regs with all the modified procedures and where they're specified regulations to carry on. Now, Mark, did you want to say something about those, or should we move on to citizens' rights appeals?
Let's go on to citizens' rights appeals, actually, because that's what I know about.
Okay, so as I say, so the EEA regs, though they're revoked, they're still very much live for an awful lot of appeals that will carry on into the future for some time, as per what we set out in the book. Part 4 of our chapter 2 then deals with these new citizens' rights appeals regulations. Now, these are quite complicated. They set out, and these citizens' rights appeals EU Brexit regulations has been amended multiple times during the period leading up to IP completion date. So if one looks at 269, first of all, they set out what decisions can be appealed against. And the interesting thing about them is that with respect to people who have rights that are relevant to them, substantive law, they're very much like the old system of rights of appeal against decisions. So they have a whole series of rights of appeal against a decision to refuse leave to enter or vary leave to remain, very much like the pre-2014 Act, Section 82 appeals. They also bring in rights of appeals for frontier workers and healthcare rights of entry. Now, all of those, what is a frontier worker, or who is a frontier worker, who has a healthcare right of entry, we introduce in the relevant parts of the book, but we don't get into the substantive law on them. but we set out what they are. And then you have a series of citizens' rights appeals that go up to 6J, Regulation 6I and 6J, as to what rights of appeal, what persons have a right of appeal. And in terms of the grounds of appeal, they're very, very complicated. 2.79, if you have a quick look at 2.79, that sets out the grounds of appeal in these type of cases. And I note that one of the questions links to this issue of the business of a right of appeal versus administrative review. There's that complication as well. We have a chapter on administrative review. So the rights of appeal all link into the various provisions of the withdrawal agreement or the equivalents in the EEA after separation agreement and the Swiss rights agreement. When Britain left the European Union, it also left the EEA, and then it also left the arrangements with Switzerland. And so there's all these provisions in the Act. And then there's the rights of appeal and the grounds that relate to frontier workers. So it's all quite complicated stuff, which I'm not going to sort of speak about, but you can see that they're set out all in the books with as much notes on it as can be done. What we haven't got on this area of law is much in the way of anything in the way of case law, because all the appeals are still presumably in the first tier level. And I haven't yet seen any reaching the upper tribunal for legal guidance. Now, Mark, you wanted to take over on this issue before we move to some questions.
Yeah, sure. So these appeals are, an interesting area. Yeah, I could chase around the book for this, but I'm just going to give myself a couple of minutes off from the chase around. So there's all kinds of interesting issues that arise in the context of EU settled status appeals. I mean, one fairly humdrum point is that they're not deemed abandoned for leaving the country, unlike more conventional immigration appeals under Section 92(8) of the NIA 2002 would be so deemed. Another point is when would someone want to appeal? When would someone want to pursue an EEA regs appeal, of which Pete was speaking about a moment ago? Given that, never mind EEA regs rights, the opportunity to get in under the wire under settled status is going to end on 30th of June 2021. And I suppose the answer to that is that probably the only people who want to pursue their EEA regs appeals rather than just go straight to a settled status application are going to be people who, for example, don't have the right documents to maintain a settled status application. So, for example, extended family members, they're not called that under EUSS, are they? They're called dependent family members, dependent parents and all that. But those people, or even durable partners, they need to have a document, a residence card. So of course they might have to pursue an EEA regs appeal to get the residence card, because the curtain came down on that for anyone who's not from Northern Ireland on the 31st of December 2020. Another possibility, I suppose, is that you could have adverse credibility finding against you in a historic appeal or from past Home Office applications. And it might be that it's obvious that you won't be able to overturn those on a settled status application, and therefore that you might as well pursue an appeal sooner rather than later. And then, of course, there's all kinds of issues about, well, if the appeal is heard after the deadline for EU settled status, 30th of June 2021, for the conventional case. Obviously, this isn't a session about the intricacies of EU settled status, but in general, would pursuing your EEA regs appeal have been a reasonable excuse for a delay? I suppose so, is the short answer to that. So quite a few things to think about there. Pete showed you the rather complicated grounds of appeal, and they're head spinning. But one interesting thing will be that, or two interesting things. One, of course, is that all those cross references to the Citizens Directive means that this is an area of law where the Court of Justice decisions will continue to have relevance insofar as English courts think them relevant. So not binding, but relevant. What approach will be taken to those? Probably a rather loyal approach, that being the style of the English courts. Other point is what does the withdrawal agreement say, which isn't in the Citizens Directive? At which point the answer is I'm not really sure, but it must all be in Regulation 18, Article 18 of the withdrawal agreement, which is the bit with the procedural rights. And it does have interesting bits in it about how the procedure shouldn't be too onerous, and about how the documentary expectations shouldn't be too tight. So it may be that the withdrawal agreement does give us stuff that we didn't overtly have when we were only working with the Citizens Directive in EEA regs appeals. Okay, yeah, so those are the points I wanted to make on that. So I think probably that
briefly on that. There's this interesting thing about the distinction between the grounds of appeal in an EEA regs case, determined paragraph 2.64, depending on when the decision was made. So you've still got the rights of appeal on the rights under the EU treaties insofar as they relate to things done or before exit day, 31st of January 2020. As you know, one of the complications of Brexit was that there was exit day when all the people waved their flags, before the pandemic started on the 31st of January 2020, and then immediately went into this transition period. An IP completion date then is at the very end of the year. And so there's all the complications that set out there, but which we set out in some detail in that particular paragraph in terms of those different rights of appeal. The citizens' rights appeals also provide, as did the old EA regs, for certain odd situations, like a certificate of removal, where the Secretary of State can remove a person who's got a pending appeal, where they feel that there's a public interest in doing so, and then people applying for temporary admission in order to make submissions in person. So those provisions are all set out in the regs and set out in the sections of the book. Now, we've reached a certain time. So Mark, should we start looking at some of the questions?
Yes, let's do that. I'm just wondering, obviously the whole point of the chat is that it's public, and so I don't see why I shouldn't screen share it.
Well, I don't know, can everyone see the Q's and A's? So we have a chat here, for example. So there's in the chat room, I see that there, amongst other things, we have a reference to where you can get the book. There's a link in the chat room, and indeed in the invite, there's a link to where the book's available. And since so many people have stayed online, I think we can share something, Mark, can't we? Which I'm now going to do, which is a code. Hang on.
24 people who I counted logging out during this year, like they're going to be ruining the day they logged out earlier.
Okay, so if you were to go to the Bloomsbury Professional thing to buy the book, and you were to make this, and you were to quote the following, I can say this because I can't send it otherwise. So capital letters BPG CCI A20 BPG CCI A20. You get a discount. There you go, from Bloomsbury. So that's something that hopefully will be an encouragement. Now, we also had a question here. Mark Peter, what are the weight of explanatory memorandum to the changes to immigration rules in JR or appeal in terms of interpreting meaning of statements in comparison to the immigration rules itself? Thank you. What do you think of that, Mark? Can you repeat the case, please?
Actually, I'm just pasting the code into the chat. Actually,
okay. Well, that's probably better.
Which is probably a better thing to do, the ideal thing to do. So, I think I got it. Yeah, okay. But unfortunately, I was doing okay, but I wasn't able to do that at the same time as listen to what Pete was saying to me. So you have another good. Which question?
Okay, so we've got a series of questions in the Q&A, but we also got a question here about the weight to be given to explanatory memorandum to the changes to immigration rules in JR or appeal in terms of interpreting the meaning of statements in comparison to the rules itself. Now, that's obviously a somewhat substantive type of question, but in terms of appeals, there's a limited issue there because obviously it goes to the limited grounds of appeal. But in terms of judicial review, what do you think of that, Mark?
Well, it's interesting. Okay, I'll make an outlier kind of point. Yeah, that we have been told by the Court of Appeal more than 10 years ago that the immigration rules were not to receive a purposive interpretation, but they were to get a literal interpretation because they didn't state their purpose. But of course, the Court of Appeal, which is, poor Court of Appeal, is simply left behind, as it constantly remarks, in a blizzard of changes, has never acknowledged the fact that the PBS routes, and indeed the Appendix FM routes, actually do state their purposes at the beginning. And you could say that that would encourage a broader approach that might include looking at stuff said in the statements of changes. So that's my hint in terms of its potential relevance, but it's kind of pretty deep water, I would say, and perhaps beyond the scope of what I was planning to talk about.
Okay, so we look now at the Q&As, Mark, if you can see those. We'll go from top to bottom, I think, if we can. So there's a question here. I've been waiting for the outcome of a recon for 7 months. Can I still JI if I receive a negative recon decision? Now, the answer to that on the face of it would be yes, because if the Home Office are making a reconsideration, then the new decision would be, because if you judicially reviewed the decision that they've said they're going to reconsider, you'd be up against the problems of alternative remedy. So in general proposition, if they've actually agreed to reconsider, you do get complications of the cases that I know of whereby the Home Office don't say they're going to reconsider, but put you on a waiting system for ages and ages, saying that they're generally reconsidering, but didn't say they were reconsidering in your case. We've seen that. But the broad answer to that would be yes. Did you consider, with regards to withdrawn appeals by law in the book, a situation where an appellant is granted leave, resulting in a similar immigration status as that under appeal where successful, though under a different part of the rules, against, e.g. appeal of refusal to grant a permanent residence card, where appellant is now granted settled status, ILR under EU-SS, on an application while the other appeal is pending? Now, in terms of the statutory Section 82 appeals, that's straightforward enough, because you have the right of you can only continue your appeal if you're granted leave to remain on the basis of asylum protection grounds. So that would answer that. With respect to, so what do you think, Mark, in terms of whether it says permanent residence card, where appellant is now granted settled status instead?
Well, that's interesting, isn't it? I mean, the questioner has been quite careful in their use of language. So, as I understand it, the point being made is, would anything happen to your EU settled status, your citizen's right appeal, if you were granted an EEA regs document in the course of it? And my hopefully not too facile answer is that I don't think so, because they're construed as independent regimes. So if you get an EEA residence card, lucky you.
I think it's the other way around, isn't it? It's the person is had applied for permanent residence card and is granted settled status.
Oh, I know, good point. Well pointed out.
Yeah. So the appeal will be presumably pending under the EEA regs, and the person then gets settled status under the new system, under the immigration rules.
I think we would say that one might say that the answer to that then is that the look, Adrian Berry would be jealous at this point, yeah, if he was here. Yeah, I've got a contribution to make about heavy EU law here. Doesn't the withdrawal agreement somewhere say something about how no one should be worse off under the sequelae to the withdrawal agreement than they would have been without it? So I think you would be entitled. I think it'd be very hard to say that the grant of a permanent residence card should damage an EU settled status appeal, or the other way around, or that the grant of EU settled status should damage the ongoing viability of a permanent residence card. That would be my answer in kind of high principle. Though obviously, if one nerdishly read all the provisions, one might come up with a more considered view.
Yes, I mean, we look at paragraph 261 in the book. There's no, in contrast to the 2002 Act appeals, there's no provision in the 2016 regs for an appeal against an EEA decision to be treated as abandoned, consequent to a grant of leave to remain or issuance of specified documentation confirming a right of residence in the UK under EU law, such as a grant of leave to remain following an application under the EU settlement scheme, does not result in an appeal against an EEA decision brought under the regs being treated as abandoned. And that the authority for that is the case of Amari. So I think there's a good answer to that one in the book. Footnote 7, paragraph 261. So I'm quite pleased about that. So there you are. Hopefully that's the answer to your question. Now, then we have another one. An application for ILR T1 was refused on the basis of deception and tax discrepancies with right of appeal. Secretary accepted their exceptional circumstances and gave the client an option to be granted limited leave to remain, presumably on the basis of exceptional circs, and gave her the option to pay for the IHS by said date. IHS. The client wanted to challenge the decision, and an appeal was lodged on the 31st of December. The tribunal deemed the appeal valid, and the appeal number was issued and directions were made. And now we've received correspondence from the Secretary of State saying that after reviewing the case, they realised that an admin error was made and a right of appeal granted in error. Secretary of State invited us to pay for the IHS, so the client can be granted limited leave. So if I'm not wrong, the court in Bala Jigari held that where an individual accuses dishonesty or false representations, such actions can be treated as human rights applications. Yes, that's interesting that, because in that case that I did mention, Aziz, where the CART JR had come along and then the person had been granted leave, and then they wanted to carry on with the appeal after the JR quashed a refusal of leave. The argument there was exactly the same, that the person had been accused of some form of general grounds dishonesty and wanted to carry on with their appeal to show that, to clear their name. And the tribunal in that case was quite clear, you couldn't do it. The jurisdiction point knocked them out. In other words, because they'd been granted leave under a 2002 Act appeal, Section 104 meant that their appeal was treated as abandoned because of the granted leave. And the fact that they wanted to use the appeal as a route to clearing their name didn't deal with the jurisdictional problem, where it was a 2002 Act appeal, not an EEA regs appeal. So I think the problem with that is the case of Aziz. And I don't want to get into application stuff with the health thing. Then we have another one. Post-Begum, deprivation appeal under Section 40A, where human rights are in play. Do you think the tribunal should assess the circumstances at the date of hearing, as in a full-blown Hwang human rights appeal, or is the first-tier tribunal essentially conducting a JR concerning human rights per Lord Carlisle, Denby, HS, etc.? If so, can the tribunal only evidence before the Secretary of State at the time of the decision? Interesting. If you have a deprivation appeal under Section 40A, and that's in play, then the statutory provisions regarding that means that evidence is available regardless. You're not limited to decision evidence on a merits appeal as a basic principle. Would you not agree, Mark?
Yeah, it's interesting, isn't it? I mean, there has been a new Court of Appeal case called Pucci on this, like last week, in which Lord Justice Underhill, in prose, of which perhaps only he is capable, goes on about these issues. And then he has a brilliant paragraph because he plainly found Begum after he'd written his judgment. And he refuses to engage with it. He's just like, he sort of invited post-hearing submissions on this. Wouldn't really like to comment very much. He kind of sidesteps it. So, but as Helen points out, I mean, there's a debate, isn't there, at the moment about the scope of the right of appeal post-Begum. Begum is a national security case, but certainly I think Pete would probably agree with me that it's rather hard to separate out the reasoning of the Supreme Court in Begum and only apply it to national security. It would seem to apply to Section 40A appeals as well.
On conducive
grounds. Yeah, conducive as well as SEAC. Well, it's interesting, isn't it? I mean, I think we would say, it's the Strasbourg court, isn't it? Isn't the Strasbourg court quite insistent that you have to have an ex nunc? Is it ex nunc or ex tunc, i.e. a date of hearing assessment? And they are quite careful in Begum to try and to distinguish, as I understand it, what they're saying about about the general discretion, little ability to revisit discretion except on public law grounds, from a human rights ground of appeal. So I think one would, if you were a claimant lawyer, I think you'd have a respectable basis for saying that, so long as I can package all my arguments into Article 8, then I'm allowed to rely on stuff at the date of hearing.
Yes, yeah. Because that must go to the question of it being a merits appeal. The Begum point, as Lord Reed's very keen on pointing out, is it's all about the Secretary of State's view of conducive to the public good, not the SIAC's or the FTT's view of what's conducive to the public good. But it can't change the nature of the statutory appeal. Where an appellant is accepted as a vulnerable adult, but the appellant's evidence that he's lost contact with a relative in his country of origin is not deemed credible, can the tribunal make the assumption that the relative is not only contactable by the appellant, but that the relative will be in a position to support the appellant despite no evidence on the relative's capacity to support being offered or considered? That's an interesting question, but obviously that's rather case specific. I mean, so the person claims they've lost contact, and that's not credible, which would mean that presumably the obverse of that is that the relevant body, the tribunal or whoever, says that the person can contact them. I can't see how being able to contact someone can then lead to some form of assumption of support of, the person can be supported by that person. So the answer to that must be that the general, where it's an important part of the individual's case that they can't get support, then I suppose they have the burden of showing that. But it can't be an assumption that just because you can contact a relative, they must also be able to support. You would agree, Mark?
Yeah, I mean, I suppose all we could really say about that is he who asserts must prove. So, I mean, what one would if that came up in the course of an appeal, for example, and the Home Office made that submission, one would try and argue that if one was representing the claimant, one would try and argue that the Home Office were asserting a fact, and therefore they had to come up with evidence. And some judges would accept that argument, and other judges might say, no, hang on a minute, the Home Office is just pointing out a weakness, a hole in your case. You could have explained it, but you didn't, and I'm entitled to draw an adverse inference. So, there you are, burden of proof, like Pete said, there's more to it than meets the eye.
Okay, good. Then we have, I think this is the same one, grant of EUSS under the rules, make a pending appeal. Well, I think we've answered that one. I think that was a grant of some form of status doesn't have the effect of automatically abandoning an appeal under the EEA regs, as distinct from the provisions in section 104. Then we have the one about the explanatory memorandum, but we've already addressed that. Then we have, I think, again, we've looked at this one, the recon decision. Now, as I say, where the Home Office has made it clear in terms that they're reconsidering a decision, and they then come up with another negative decision, it would be the negative decision on reconsideration that would be amenable to judicial review. You'd agree, Mark?
Yeah, totally agreed. Yeah, totally agreed.
Any chance of bringing back rights of appeal for visit visas from abroad? Well, there is provision regarding family visits and where Article 8's engaged, and the Home Office have some guidance on that. But I don't think I can answer that one.
Wasn't there something in the statute when they abolished it? Isn't there some 5-year review which may or may not have come up? It's one of those things that it's still, one could lobby one's MP about that to make sure that one's voice is heard, I suppose, about the importance of that right of appeal.
Okay, then we have a question which starts again. So section 86, the tribunal must determine any matter raised as a ground of appeal. Therefore, the immigration judge must consider all grounds raised. So cannot have the situation where the immigration decides one ground in favour of appellant and therefore says no need to go on to consider other ground. Example, on a deport appeal, if immigration judge finds in favour of the appellant under 11741 integration, the judge still needs to go on to make decisions on exception 2 unduly harsh on partner grounds if they have been raised as grounds. So no room for lazy IJs. Interesting. I mean, a ground of appeal that the decision breaches human rights, if it's allowed, to the extent to which a judge is obliged to go on to consider, so the judge decides that you succeed under the rule, does the judge then have an obligation to consider the matter under the exceptional Article 8 proportionality? Interesting. I think that if the judge allows the appeal on Article 8 grounds, so is the human rights appeal allowed, with the reasoning simply stopping at integration issues, section 117C4, so forth. One thing is clear, is that you, the appellant, could not then appeal that decision to the upper tribunal. Because there's quite a lot of case law on that. So the appeal is allowed. There's a very recent case, in fact, that's not in the book, Mark, that you did, which was the business of when a decision is made, positive decision can't be appealed by the winning side. So, one can grumble about it, but I think the answer to that is if the judge allows the appeal on the basis that the provision in the rule is met, but then doesn't go on to consider the exceptionality issues, accusations of laziness can be made, but I don't think there's a remedy for that in terms of the statutory appeals provisions. What do you think, Mark?
Yeah, Pete's completely right. Yeah, I mean the only thing I can think of is that in the days when refugee exclusion was first written about in the Upper Tribunal, they came up with some case law called the belt and braces doctrine, in which they said that the first tier tribunal or its antecedents had to deal with everything, inclusion and exclusion, even if exclusion was apparently definitive of the outcome of the appeal. And they called that the principle of judicial economy. So, I mean, that's what, in a sense, that's what, if you want findings on alternative issues, because you're concerned that the Home Office might appeal if you only win on one ground, then you could encourage a first-tier tribunal judge to, to determine all issues, to make the decision more watertight. But against you will be the principle of judicial laziness, which might actually stop them in their tracks. They might actually think, well, I've done enough now. And as Pete says, there's no real legal doctrine to help you either way. Yeah. Okay. So
we have a follow-up to that. The problem is that the Home Office then appeal on the first round and win. So have an appeal on the second round again. Okay. I mean, of course, what's quite clear is that if you win on the first issue and the Home Office, the losing side, lodge an appeal, you can definitely put in a Rule 24 response saying that the judge was right to have allowed the appeal on the statutory provision, but should also have allowed it on the exceptional Article 8 proportionality grounds. That's definitely right, isn't it? And whether you win or lose on that's another matter, but you can bring you can't initiate the challenge to the first tier decision in which you win, but you don't win as well as you hoped you would. But if the Home Office challenge, as of course if it's a default case, they inevitably do, the Article 8 win, then you can bring in because that's not a new, there's case law that says that if you have an appeal pending on refugee asylum and also human rights grounds, and it's allowed on one but not on the other, then there's this issue of appealing on the ground that you lost, rather than being subject to having to raise that on a response, Rule 24 response. But where you win your appeal on either the protection ground or the human right ground, but you don't win it as well as you hope to, let's say on the human right ground, then you can raise your extra human rights issues on the Rule 24 response, which means that if the error of law is found by the Upper Tribunal, so then your issue is back in front of the Upper Tribunal on the substantive reconsideration or on a remittal. I mean, that's right. What happens where it doesn't work, then that's another matter. We're going to run. There are other questions, but we're running out of time now. So, we are hoping to have another one of these sessions where some of these questions can no doubt come back. What do you think, Mark?
Yeah, who's that Greek god who was doomed to always roll a stone up a hill? There's a Sisyphus, yeah. There's a Sisyphean element to this, isn't there? In that, while Peter's been doing his excellent exposition of the questions and helping with the answers, actually the numbers of questions are just doubling every 2 minutes. It's like COVID. So I think we're going to have to start. I think we're going to have to draw a line under it at this point here. But we'll bear in mind these questions are saved, and it's conceivable that we might generously have a look at them in the future. Otherwise, join us for the next session when we're going to look at the Upper Tribunal in its manifestations, both as a statutory appeal body and also as a judicial review determining body. So, and that's on 12th of July, as per the reminder that's just most excellently popped up in the chat box. So thanks very much for joining us, everyone. And in fact, this was the most heavily subscribed Garden Court Zoom there's ever been. We had nearly 500 subscribers. So we are humbled at the potential attendance, even if 3/4 of them didn't last all the way through.
Yeah. Now we're also getting questions about the code. I'm afraid that's really something you're going to have to address to Bloomsbury. You understand, obviously, that we write the book, but we write the book, and then Bloomsbury take 90% of the proceeds. So all questions like that, I'm afraid you're going to have to address to Bloomsbury Publishing. The code was something that they provided for us to promote the book, so that's what we've done. So good luck with that one, and thanks everyone for attending.